Now on, we can start the meeting and have bang the gavel. May I introduce people who are here today, which is Olivia Quinn, Democratic Services, Rachel Gray, Licensing, Maggie O'Hare, Licensing, and Nigel Bell from Legal. With me are two councillors, Councillor...
Caught me by surprise. Councillor Ian Shenton. And Councillor Chris Mills.
Thank you. Before we start, can I make sure that if you're talking into the microphone, that your mouth is quite close to it, because otherwise it's not picked up properly by the machinery, and it doesn't go out properly to people who might be watching. Okay, so the first issue on our agenda is to consider an application from Mr. David Hurd. Oh, sorry, needed. Oh, yeah. Sorry, I'm leaping ahead. Apologies?
We've got no apologies, Chair.
Disclosure of interests? No, no disclosure of interests. We can now move on to the... to consider an application from Mr. David Herdman, trading as CJH of Shottery, dated 4th March 2025, for the renewal of a private hire vehicle licence for a vehicle registration number DH09CJH. The vehicle exceeds the maximum age as set out in the policy of the Council. So, may I move to the setting out of the issues, please? Thank you.
Thank you, Chair. Morning, panel. Mr. D. Herdman, trading as CJH of Shottery, is seeking permission for an extension to the private hire vehicle licence plate number 205. Registration number DH09CJH. A copy of the letter from Mr. Herdman is attached at Appendix 1. The vehicle is a white Tesla model P90D, which is wholly electric. It was first registered on the 19th of September 2016. The vehicle logbook V5 confirms this and is shown at Appendix 2. The vehicle was first licensed by Stratford District Council on the 16th of December 2016. A copy of the Stratford District Council Hackney carriage and private hire policies will be provided to the licensing panel with this report. The section entitled Private Hire Vehicle Licensing Criteria is found on page 11. Paragraph 3.2 of the Private Hire Vehicle Licensing Criteria states that vehicle licences will not be renewed once the vehicle is over 6 years of age from the date of first registration. The restriction on a private hire vehicle being licensed after 6 years had elapsed and was last considered by the Regulatory Committee in February 2013, when it considered a report entitled New Standards for Taxi and Private Hire Mechanical Testing. The recommendation to the Cabinet was that private hire vehicles should benefit from an extra year of being licensed due to the enhanced testing of vehicles, allowing them to be licensed for 7 years in total. The Cabinet resolved to amend the age policy to enable vehicles limited to 6 years of age to benefit from the additional year, up to 7 years of age, if they pass the new type of inspection. An excerpt from the minutes of the Cabinet meeting held on the 2nd of March 2013 are also attached at Appendix 3. The application fee is calculated to cover a 12-month period. This enables officers to annually check that the correct level of insurance is in place and that the correct number of MOT and taxi test inspections have taken place during the licensed period. On the 4th of March 2025, Mr. Herman submitted an application to renew his private hire vehicle licence for a further 12 months. The current private hire licence is due to expire on the 11th of April 2025. At the time of this renewal, it was established from supporting documentation that the vehicle was 8 years and 4 months in age and was already outside the age policy for the class of vehicle. And the mileage at the time of writing this report was 175,124 miles. The matter was discussed with Mr. Herdman, who respectfully requested that the application be placed before the licensing panel for consideration. The vehicle was subject of the same application last year and was considered by the licensing panel on the 8th of May 2024. The licensing panel resolved that the private hire licence would be renewed for a further 12 months. The panel stressed that it expected Mr Herdman to comply with all the conditions of the licence, including the requirement to subject the vehicle to the required 6-monthly mechanical testing. This has been complied with by Mr Herdman to date. The licensing panel's resolution is shown at Appendix 4. The vehicle has been made available and you have inspected it earlier this morning. The vehicle was MOT and taxi tested on the 3rd of March 2025 by an authorised garage and was found to be mechanically fit. These are shown at appendices 5 and 6. So options available to the licensing panel today. To exercise its discretion and renew Mr Herdman's private hire vehicle licence in respect of vehicle registration DH09 CJH for such a period of time as the licensing panel considers fit, or to refuse the application for the private hire licence to be renewed. The appendices contained in this report constitute the evidence which appertain to the request from Mr Herdman. Licensed drivers and their licensed vehicles are an integral part of the transport system for both the residents of the district and visitors to it. Vulnerable people regularly use their services. The Council's plan states that we are looking to respond to the climate emergency and should be nurturing a thriving, innovative and inclusive economy and putting residents and communities at the centre stage. The use of electric or hybrid vehicles are encouraged by this authority, but it remains a choice of the individuals which vehicles they want to licence. The vehicle subject of this report is wholly electric, and it is for this reason alone that Mr Herdman wishes the matter placed before the licensing panel for consideration. Thank you.
Thank you. May I call on Mr. Herdman? May I ask Mr Herdman to put his propositions forward, please?
Good morning. Thank you, panel. Thank you, Maggie. Yes, I'd like to propose that my Tesla to be renewed for another further 12 months to be used for private hire within the district. As you can see from the state of the vehicle, been looked after. The mileage shows it has worked a lot and still withstood all of the work that it's done, and mechanically sound with the 2 MOTs and private hire checks yearly done. Excuse me. I'd just like to submit the vehicle is fit for purpose for another 12 months.
Thank you, Mr Herdman. Do we have any questions?
I don't have any questions. No.
We have no questions. Actually, I do have one. Who do you actually mainly transport in your vehicle? Is it the general public or?
It can be the general public. I was mentioning to one of the councillors during the inspection that I do get work from Stratford locals, Birmingham airport trips, Silverstone coming up. I've got bookings for Silverstone. But I also do a lot of work, and I have done all of my driving career, which is 20 odd years, for the RSC. So I look after a lot of the RSC departments, going to London, backwards and forwards, not only with customers, but also costumes and some equipment sometimes. So it's a bit of a range of a little bit corporate, a little bit private, and inside and outside Stratford area.
Thank you.
Thank you, Chair. Just going back to the previous panel and looking forward, can you give us an absolute guarantee that you will continue to comply with the 6 monthly testing
100% guarantee that, Councillor. Yes, it's already booked in my diary. I can't book in my garage that far ahead because he won't take it that far ahead. But it's in my diary for the next 6 month MOT test and private hire test.
Thank you. No further questions? Okay. Thank you, Mr Herdman. We will now consider your application and we'll get back to you within 5 working days maximum. Thank you very much.
Thank you very much.
Sorry about that. We moved from one to the other rather quickly and I hadn't actually got the right page. So in fact, we're now moving on to consider an application from Mr. J. Faulkner for the renewal of private hire vehicle for vehicle registration number CK63EFS, plate number 494. The vehicle exceeds the maximum age as set out in the policy of the council. So if I may ask for to talk us through the conditions. Thank you.
Thank you, Chair. Good morning. Mr. Faulkner is seeking permission for an extension on the private hire vehicle licence plate number 494, registration number CK63EFS. A copy of the email from Mr. Faulkner requesting an extension is attached as Appendix 1 in the report. The vehicle is a Ford Mondeo. It was first registered on the 21st of January 2014. The vehicle logbook, the V5 document, confirms this, and this document is shown at Appendix 2. The vehicle was first licensed by Stratford-on-Avon District Council on the 22nd of December 2015. A copy of the Stratford District Council Hackney carriage and private hire policies have been provided to you with this report. The section entitled Private Hire Licensing Criteria is found on page 11 of the pamphlet. Private hire vehicle licensing criteria states that vehicle licences will not be renewed once a vehicle is over 6 years of age from the date of first registration. And following a Cabinet meeting held on the 2nd of March 2013, the recommendation was that private hire vehicles should benefit from an extra year of being licensed due to the enhanced testing of vehicles, therefore slowing them to be licensed for 7 years in total. The Cabinet resolved this amendment to the age policy and therefore is extended to 7 years of age. The document confirming this information is shown as Appendix 3. The application process. On the 10th of March 2025, Mr. Faulkner submitted an application to renew his private hire vehicle licence for a further 12 months. The current private hire licence is due to expire on the 17th of April 2025. At the time of the renewal, the vehicle will be 10 years, 2 months in age and is already outside the age policy for the class of vehicle. Upon renewing his private hire vehicle licence in April 2014, Mr. Faulkner sent an email to the licensing team on the 16th of February 2024 stating that this year would be the last of renewing as he was retiring, and on this basis his renewal application was permitted at the time. This email is shown as Appendix 4. Mr. Faulkner undertakes school contracts and has indicated that he wishes to continue these as the school children he transports are under SEN, special education needs, and in care. He wishes to see them through their school journey. Based upon this information, Mr. Faulkner has requested that his application be placed before the licensing panel for consideration. The vehicle has been available to yourselves and you've inspected it prior to this hearing. The vehicle is owned by Mr. Faulkner and he holds a private hire operator's licence which expires on the 25th of January 2026. His operator business is RT Private Hire. The most recent MOT test was carried out on the 8th of March 2025 by one of the council's approved garages and was found to be mechanically fit. This is shown as Appendix 5 of the report. Appendix 6 also shows an MOT history for the vehicle for your consideration. Options available to the panel. To exercise your discretion and renew Mr Faulkner's private hire vehicle licence in respect of vehicle registration number CK63EFS for such a period of time as the panel considers fit, or to refuse the application for the private hire licence to be renewed. Paragraph 5.3, Council Plan. So the licensed drivers and their vehicles are an integral part of the transport system for both the residents of the district and the visitors to it. Vulnerable people regularly use their services. The Council's plan states that we are looking to respond to the climate emergency and should be nurturing a thriving, innovative and inclusive economy and putting residents and communities at centre stage. The use of electric or hybrid vehicles are encouraged by this authority, but it remains a choice of the individuals which vehicles they want to licence. The vehicle in question is diesel, as specified on the application form. Conclusion that the licensing panel must decide if this private hire vehicle licence should be renewed, subject to an exemption to the Council's policy. Thank you.
Thank you very much. May I ask Mr Faulkner to actually put his case? Thank you.
I got it. Okay, sorry. Yeah. Ooh, I got a shout. Yes, I'd like you to consider it as I've sort of retired, semi-retired now, and I would like to carry on with the school contracts to see the children that I take through their journey as much as I can. I have one. I was, as I said at the, Rachel said, would intend on packing up this year, but there's one child that has decided to stay on for another year, which it took a lot of nurturing to get him in the taxi 3 years ago, and now he just comes in, and I think he would struggle with another taxi. I have a girl in care, which is a tricky one, which I can't say too much about, and I'd like to carry on, basically, and so I could get it all sorted. If you wouldn't agree, I'd like to go to the January where my all my licenses run out, which is my dual license and my, what's the other one called? Operator's license, all run out altogether. So I could, and if the lad takes on another year, which we're not sure about yet, I could work that through to another driver. Thank you.
Thank you.
Oh, sorry, I do nothing else but school contracts now anyway. I don't do any private hire.
Thank you, Mr Faulkner. Switch. Are there any questions, please? Councillor Mills.
Thank you very much, President. How many miles has it done? I didn't think to look when we looked at 225. And the size of the engine is? 2 litre, thank you.
Any further questions? Councillor Shilton.
No, yeah. I'm just wondering how to formulate this. It's a question for you, Rachel, on this. Mr Faulkner has mentioned that his dual licence, operating licence, etc., runs out in January 2026. But we would normally renew for 12 months.
Yeah,
Are there any implications that we should be aware of because of that?
Not as far as I know. With Mr Faulkner, I have no issues with him whatsoever. There's no history at all. In fact, it's probably the first time I've met him today. So, but certainly, yes, the private hire operator licence does end in January 2026, and your dual driver badge ends just same, Jan 2026. But this is for an extension to the age policy of 12 months, if agreed.
May I ask a question? You obviously have great concerns about the young man that you've been able to persuade to go on to college, school, whatever. If you do finish before he actually completes his education, what happens at that point? What?
took it off. It took me quite a while to, you know, nurture him into the car without his mother, and that's the way it is really. He's doing well now.
Sorry, could you... Whatever the outcome of this consideration is, if you were to continue for 1 year, would you undertake actually making sure that this young man could actually move on to another driver to continue his education? Seems a grey area to me.
Well, the council, it has to be put to the council, and they'd have to find somebody and go through the process like I went through, I suppose. But I mean, he's 2 years older now, so I don't know.
Thank you, Mr. Herdman.
Okay.
It's Warwickshire County Council that Mr Faulkner is referring to, not Stratford District Council.
Yes, yes.
School contracts, yes.
Yeah. I'm quite aware of the counties involved, well, sort of lead on send and school transport. So it would be a discussion elsewhere, not here. Thank you. Right, any more questions? Thank you.
So just very quick one for you, Mr. Faulkner. Bearing in mind that you're looking to retire in January.
Yeah.
The next test is due September, October.
Yep.
Do you give can you give me an absolute assurance that you will get the vehicle tested, even though you may only run for another 3 months?
Exactly, I would, yeah. Safety is ultimate, especially with children.
Thank you. If there are no further questions, thank you, Mr. Faulkner. We will actually consider the application and be in touch within 5 working days. Thank you. if we're all ready to start the meeting at just after 11:05, okay? My name is Councillor Jenny Fradgley and I'll be chairing this meeting. Before I start, I believe Councillor Shenton wishes to say something.
Yeah, I'd like to disclose that the ward member did contact me yesterday, but we didn't speak about this matter. So I come here with a totally open mind. Thank you.
Thank you, Councillor. Today, Olivia Quinn is Democratic Services, Vicky Goodman is Licensing, and Legal are Nigel Bell and Nisha Lowry. Councillors here present?
Councillor Ian Shenton.
And Councillor Chris Mills.
We're here today to determine an application for a variance of a premises licence for Blackwell Grange, following objections relevant to one or more of the licensing objectives. May I call on Vicky Goodman to start the hearing?
Thank you, Chair. Good morning. Good morning, everyone. So as you've rightly said, you're here today to consider an application to vary the premises licence currently in place for Blackwell Grange. As you said, this matter needs to be determined by you as there are objections to the application from a number of residents. The applicant, a Mr. William Vernon Miller for Blackwell Grange Weddings Limited, who is here today together with his wife and business partners, I believe, who is also represented by my learned friend, Mr. Rankin, describes the premises as an exclusive use wedding venue consisting of a ceremony barn, reception, dining barn and terrace with limited number of bedrooms to accommodate immediate family. The premises is located within Blackwell Village, and within the report pack that you have before you today is a location map shown at page 43. Since the report was written, an evidence bundle has been provided by my learned friend, which contains a statement from Mr. Miller, who states that the venue is also used for gala dinners, birthday parties, entrepreneurship courses and creative workshops. This is a variation to the existing licence, a licence that has been placed since 2016, and a copy of the existing licence can be found in the reports packs from page 45 through to 53. The current licence permits the following: the sale of alcohol for consumption on the premises every day 11 until 2300 hours, live music indoors only every day 11 until 2300 hours, and recorded music indoors every day 11 until 2300 hours. By way of information, the initial application, which was applied for in 2016, also received significant objection. As you know, when this happens, we must hold a hearing for a licensing panel to determine the application. A copy of the record and of the hearing and decision can be found on pages 55 to 64 of the report. The application that is being considered today seeks to increase the times for recorded music, the sale of alcohol, and to allow some music to be played outside. There is also a request to remove or amend a number of conditions and increase the licensable area. A copy of the full application, together with the new plans, is contained within this report, viewable from page 65 through to 79. Now, since the application was originally submitted, there have been some amendments to what was initially proposed. I don't want to confuse matters, so I'm purposely not going to go into what was initially applied for. You can see that it's contained within the report. What I will do in a moment is let you know what the current position is, what is now on the table, so to speak, for consideration. As I mentioned before, we're here today because the Licensing Authority has received objections from residents in respect of this application. There were 31 in total. All of the objections that were valid and received within the consultation period are contained within the report before you. I'm sure you have read them all, so I don't intend to go through them. Those that wish to be represented by Sorry, Chair. You've got those before you. What I was going to say was that some of the residents have indicated that they wish to be represented by Lisa Gillian from Free Solicitors, and she's here today. I've given you a list of people that want to speak, which you will call upon in just a moment. As with all applications of this nature, consultation was sought with all of the responsible authorities. During this 28-day consultation period, correspondence from this council's planning enforcement team was received, and a copy of that correspondence is within the report at page 81. Planning have not objected to this application. The planning officer has indicated that there may be some restrictions in place in respect of planning that might require the applicant to also apply to vary their planning permission conditions. By way of guidance, the Section 182 guidance issued in respect of the Licensing Act 2003 provides the following advice. In the context of variations or minor variations which may involve structural alterations to or change of use of the building, the decision of the licensing authority will not exempt an applicant from the need to apply for building control approval, planning permission, or both where appropriate. The guidance also goes on to say there are circumstances when, as a condition of planning permission, a terminal hour has been set for the use of premises for commercial purposes. Where these hours are different to the licensing hours, the applicant must observe the earlier closing time. Premises operating in breach of their planning permission would be liable to prosecution under planning law. So in summary, the fact that the premises do not currently have planning permission in place does not preclude them from applying to alter their licence. The premises would still be bound by these permissions and could be liable under planning law if they were found to be in breach of them. Moving on from planning, Environmental Health responded during the consultation period to advise the agreement of amended times and conditions. On this basis, Environmental Health have no further representation to make in relation to the application. A copy of the agreement is contained within the report at page 83. There is probably a slight typo that I should point out. So if you go to page 83 of the report, where the Environmental Health Officer has stated regulated entertainment, I think it's the 5th paragraph from the bottom of his email up. I think he's put regulated entertainment to cease at 00:30 hours. By regulated entertainment, he means recorded music. So moving on, none of the other responsible authorities have chosen to make comment on the application before you today. To assist, I have provided information relating to temporary events applied for by the venue since its opening, together with a history of complaints made to the District Council. That can be found on pages 87 to 89 of the report. As I mentioned before, there have been some amendments to the application initially sought. What has agreed, or rather what is for consideration at this point, is as followed. Now, before you all start scribbling, I do have copies of what I am about to say so that you have it in hard copy. You don't have to try and write all of this down, but I will try and summarise. It is quite it is complicated, so bear with me. So the existing licence permits the sale of alcohol for consumption on the premises only, currently 11 until 2300 hours. This application seeks to allow the sale of alcohol for consumption both on and off the premises every day between the hours of 11 until midnight with a 30-minute drinking up time. The existing licence permits live music, indoors only, 11 until 2300 hours. What has been agreed between the applicant and Environmental Health is that live music, both indoors and outdoors, would be permitted every day, 11 a.m. until 2300 hours, but outdoor live music must cease at 1900 hours, with windows and doors to the barn or the entertainment venue closed at this time. Condition 23 on the existing licence states only acoustic music is to be permitted outside and only between the hours of 12 noon and 7 p.m, 1900 hours. This condition is to be amended to read acoustic and amplified music permitted outside between 12 noon and 7 p.m, ensuring the sound remains at a low, non-disruptive volume appropriate for the setting, so effectively background music. As such, condition 24 is to be removed. That condition was that no amplified music is to be played outside at all. Condition 25 on the existing licence states that external doors and windows shall be kept closed whenever amplified regular entertainment is in progress, except for access and egress. That condition is to be amended to read, external bifold doors permitted to be open up to 1900 hours for the purpose of creating a pleasant atmosphere while ensuring the sound remains at a low, non-disruptive volume appropriate for the setting. After 1900 hours, all windows and doors to remain closed except for access and egress whenever the premises is used for regulated entertainment, so live or recorded music. Condition 28 on the existing licence states that a noise limiter is to be fitted and operational at all times, and that's to be set by the Environmental Health Officer at Stratford District Council, and all amplified regulated entertainment must pass through the noise limiter. Condition 28 is to be amended to read, after 1900 hours, all regulated entertainment shall be through the installed sound ceiling, which has an integrated sound compressor limiter. The levels of the sound ceiling compressor shall be set by the Environmental Health Officer and shall be maintained at that level unless required to be altered by the Environmental Health Officer. Currently, recorded music is only permitted every day between the hours of 11 and 2300 hours. What is now being sought is recorded music, again that remains indoors only, is to cease at midnight with background music only until 30 minutes past midnight. Condition 19 will remain, and the external areas to be closed and cleared by 2300 hours. As I said, I do have all that written down, so I will circulate it in just a moment. The matter is for you to consider today based on all of the representations that you're going to hear. After hearing from everyone, you have the option to grant the application in its current form or by modifying any of the conditions that you consider appropriate for the promotion of the licensing objectives. You can also reject all of the application or part of it. That concludes my summary of where we are at currently. If you have any questions.
Please, could you circulate the document that you have? And may we take just a few minutes to look through it, please? Can we just take 5 minutes? 5 minutes, councillors. Thank you very much. I've been actually advised that there will be no cross-examination during this. It's just councillors who will be asking questions. There's been an alteration in the running list of speakers that I've been given, so if I might just run through that so we know who's coming when. James Rankin, barrister, will be representing the applicant, Mr. William Miller, followed by Ian Wilson, parish clerk to Treddington Parish Council, followed by Paul McPherson, Nick Daniels, and then finalising with Lisa Gillingham. So that's the running order that I have here. So if we may start the proceedings with James Rankin speaking on behalf of Mr. William Miller. Thank you.
Thank you. Can I explain that I have a number of people in your committee room. Didy and William sit on either side of me. Scott Bradbury is the executive bars manager. And then over on this side of the room, because I wouldn't want you to think that everybody here is objecting to me, over on this side of the room are those who are involved in one way or another with the operation of the premises. I've got the general manager. I'm not proposing to call all of these. I've got the chief executive of Artemis. I know that you will have read the statement from William and Dee Dee, and in it, it explains that they are the people that own the farm. Artemis are the people that effectively do the catering of the events there. So all of these people are from Artemis. I've got Simon Robson. I've got Matthew Wilson, who's the executive operations manager. I've got Stuart Owens, who's the chief executive of Artemis. And I've also got Stuart McNeil, who's the general manager of the premises. But as I say, I'm not intending to call all of them. Now, when you read the statement, and will you forgive me if I just summarize some bullet points that are contained in it, because they're important to recap on. William and Dee Dee are farmers. Dee Dee's family have farmed this farm for 80 years, started in 1944, shortly after the war. And it's not big, it's 120 acres, and you will take judicial notice of the fact that farmers are having a difficult time of it. And in 2016, they diversified, and they applied for permission and were granted to have 27 acres as a solar farm, and that helps. And then in 2016 also, they applied for and were granted this license, which we're currently seeking to vary. Now, it's important to note that when we applied for the license, I didn't appear on behalf of William or Dee Dee then, the premises had not operated. They were conditions which were imposed in an attempt to predict what might happen at the premises. We've now had 8 years of trading, and we're able to show you with some conviction precisely how it is that these premises trade, and give you some reasons as to why it is that we would wish to vary those old conditions imposed as they were in 2016. Ms. Goodman has correctly identified that it's not just simply weddings that we do. Gala dinners we do, 60th birthday parties we do, workshops for creative enterprises, and so on and so forth. But the main business that we do are weddings. And although we have a capacity of 150 persons, the average occupancy of a wedding varies between 75 and 84 people. Now, when the license was imposed back in 2016, they were given a cap of 11 o'clock, and that mirrors the planning permission that they had. And we've applied to vary the planning permission so that if this license is granted, then it will marry up with this variation as well. And all that they're seeking in all of this paperwork is simply this: please, can we have 1 extra hour with half an hour's drinking up time. And the residents will say, no, they can't. And we say, please, can we? And the reason that we say this is because if you were to drive within a 15-mile radius of these premises, you will come to 6 venues, all of which have a later terminal hour. These venues all cater for weddings. And the simple fact of the matter is that we are losing business because we do not have a later terminal hour. Every booking that is rejected by a prospective booker is rejected because we have 11 o'clock. And what we're seeking to do is to restore some form of commercial parity so that we're able certainly to compete with the other wedding venues, but also to try and win back some of that business that we've lost. It's not the intention of William or Dee Dee to increase substantially the amount that historically have ever taken place at these premises of weddings. It's simply to restore the position that we've lost. There are other conditions that relate to the noise limiter, which was imposed as a condition back in 2016. You'll know the way that these things work. Noise limiter, they're pretty redundant in terms of equipment nowadays, but they're effective. And a noise limiter was installed and set by the environmental health officer way back in 2016. And then in 2018, we installed something called a sound ceiling. And William has attempted to explain how that works. But if you can imagine this is our dance floor. The sound ceiling has 400 speakers in it, and they're all directed immediately underneath onto the dance floor. So that if you and I were standing on the dance floor, we wouldn't be able to hear each other speak. If we moved 3 steps to one side, away from the dance floor, we could hear each other speak. And this piece of kit costs £40,000, and it has rendered the noise limiting device obsolete. So we thought, with the blessing of Ben Ellis, and I have to say we've been extremely grateful for the professionalism and the expertise of your environmental health officer, because he has given us invaluable advice and experience and so on. And with his blessing, we've been able to set the levels for the sound ceiling so that they are at exactly the right levels, in his professional opinion, to ensure that all of the other conditions on the license are adhered to. So the proposal is simply to amend the condition to remove the noise limiter, which with Ben Ellis's blessing we disconnected last week, and to replace it with this new condition relating to the sound ceiling, far, far superior to any noise limiting condition. But this is the danger sometimes when you have 1 or 2 prime movers in an objection. And I'm going to choose my words very carefully, but you will have seen it before. You have somebody that agitates amongst residents and prophesies all sorts of disasters. And one of those was a suggestion, and you can see it shine through in these objections, a suggestion that we were going to remove the noise limiter altogether, without recognizing that we're replacing it with this new wonderful system. So the vast majority of the objections that you've read are based on misinformation. This being the misinformation, that they're not going to have any form of noise attenuation at these premises, that it's effectively a free-for-all. And so you'll see time after time these objectors saying, don't remove the noise limiter, it's worked really well over all these years, without recognizing that what's been working really well over all these years is the sound ceiling, not the noise limiter. So you'll see how dangerous sometimes misinformation can be. Here's another for instance. we're not allowed to have amplified music outside. We're not Glastonbury. We don't intend to be Glastonbury. We don't have any festivals or anything of that nature. But from time to time, we have classically trained sopranos who have their music accompanying them. That music, which is amplified, can't be played outside. It has to be played inside. And this is the bizarre thing. If you look at the conditions of our license, we could, if we wanted to, but we don't, have a 30-piece brass band playing outside. It's not amplified, it's acoustic only. Makes far more noise than a classically trained soprano and her accompanying music or the accompanying electric piano. We could, if we chose to, have a 60-person gospel choir. We've been asked to host that, but we don't. And the reason that we don't is because of our respect and deference towards the residents. We don't do any of those things because we don't want to upset the residents. So this, in a nutshell, is what we want. We want to have somebody outside. The civil ceremony takes place in the thatch barn, and then that's usually about 1 o'clock. And what then happens is that there's a reception on the terrace, and then at 3 o'clock they move into the orchard barn, where they are seated and given their reception, and then there's speeches and the rest of it. By and large, the activities that we seek amplification for are very few and far between, and by and large, they will take place within that window after the civil ceremony and just before they sit down. So most of it will be happening in the afternoon. Occasionally, very, very occasionally, we will have a classically trained soprano who wants to sing in the evening. So we approached Ben Ellis and we say to Ben Ellis, what do we do? And Ben Ellis sits down with us and composes conditions, appropriate conditions, bearing in mind what it is that we want. And that's why we've been able to agree the conditions in the shape and form that they have. Now, in order to, because we had no idea of the level of residential objection until Vicky Goodman kindly sent us the representations in late February. And we then organised a public meeting at Blackpool Grange with the residents so that we could explain precisely what it was that we wanted. We set an initial date, and 1 or 2 residents complained that it wasn't convenient to them. We moved the date. They didn't want it in the morning, they wanted it in the evening. We moved the time. And so on the 12th of March, all of the people that you see with me were assembled at Blackpool Grange to answer any of the concerns of the residents and to put into perspective what it was that we were seeking. And at that stage, you'll recall, we were looking for 1 o'clock plus half an hour's drinking up time. And it was perfectly clear that the residents were concerned about the noise limiter. We explained, as best we could, what the position was on the noise limiter. And I believe that the residents now understand what the position is. If there's any doubt, I hope that this hearing clears it up. And then we explained the position in relation to the acoustic music outside and the rarity of its occurrence. And the response, I regret to say, and one sees this sometimes, was, well, you could have it until 7 o'clock. And the answer to that is, yes, we could, but by and large, we won't. And what we'll be having is 1 or 2 people and an electrified, amplified instrument. And then William says this, I tell you what, if there is concern, we can play that amplification through a piece of equipment inside the premises in order to restrict the amplification outside. And some people like that idea. We're still prepared to offer that as a condition. And then William and Dee Dee went away, and they consulted with Artemis. And in the spirit of compromise, they said this: look, all right, we will peg back the hours that we seek until midnight. We will forego that extra hour. We will get an hour's extra trading, which allows us to sell some, but not all of the weddings, because there still will be people who will decide that they don't want to go to the bother of hiring our premises if it has a short terminal hour. And we thought that that would provide a sensible compromise to bridge the gap between the two sides, and to see whether it was possible to find common ground. I regret to say that offer has not been accepted so far as the residents are concerned, and as I understand it, they're still dug in, which is a matter of some regret, because viewed in the round, what we're asking for is relatively modest. Now, here's an extraordinary thing, and I point this out in Dee Dee and William's statement, that although what we're asking for is an extension of ours in order to sell the venue so that people will hire it, the reality is that on occasions when we've done this, and we've done this with the encouragement of Ben Ellis, your environmental health officer, he said, look, apply for temporary events notices. I will monitor them, and I will take readings, and I will find out whether there is any impact from these premises going to the hours that you seek. And if you look at page 87, I'm not asking you to do this immediately, but if you look at page 87, you'll see that we had some old 10s. We had 4 10s pre-COVID, and then post-COVID, we've had 4 10s until 1 o'clock in the morning. In other words, longer than we seek today. And this is the curious thing, that although we can't sell premises unless we have a later terminal hour, the take-up of the later terminal hour is relatively small. And what I mean by that is this, that if you look at the reality of what happens at a wedding, what generally happens is that people my age tend to peel off at about 9 o'clock, because quite frankly, we'd had enough by then. It's been a long day. You have the diehards that go on till 10 or 11. And then you've got stragglers left. When we had a 1 a.m. terminal hour, you've got stragglers left at the end. So although you can't sell the venue unless you've got a later hour, the take-up of the later hour, the actual use of the later hour, is very limited. And it's the same for the sale of alcohol. You've got residents saying, well, if you have an extra hour or 2 hours, that's 2 hours extra drinking, and you're going to have people who are going to be drunk. The reality is very different from that. The take-up of the sale of alcohol is relatively small. So it's pretty steady up until 10 o'clock, and then it falls off a cliff after that. So you can't sell the venue unless you've got the later hour, but in reality, people making use of the additional hours for the purchase of alcohol is relatively small. So I hope that I can put it into context that way. So what we've done then is we've had these late 10s. Ben Ellis has been able to monitor precisely what goes on, and to give you a full picture of what he believes is the right course for this application. I should say that he would still support an application until 1 o'clock plus half an hour's drinking up time. So he is fully convinced that we're able, with these conditions, to operate until 1 o'clock plus half an hour. But despite that, and in deference to the residents, we have pegged it back till midnight. So there are a number of other issues that were raised by the residents. And I'll give you an example of those. In our pack, at page 14 of our pack, is a plan, and it looks like that, which I know that you will have seen. I'm just going to hold up my plan and show the residents what I'm looking at. And it's simply this. This was the old drive to the farm. There was a drive which was pre the grant of the license, which allowed people to go in and out of the farm through the village. So before we started operating as a wedding venue, we reopened the drive, and now when people approach the venue, they go in down through that drive and they leave through that drive. Now, there were a number of issues that the residents raised, and they raised this problem about people driving through the village after the event. And obviously, we can't stop people driving through the village. But by and large, the taxi firms that we use are almost exclusively based over to the right-hand side of our plan. And we've been in touch with every single one of them, and we've said this, that when picking up and dropping off, will you please ensure that you do not turn left and go into the village. And just to hammer that home, we have very recently applied for, they haven't arrived yet, have they? No.
They're being made, they should come next week.
So they're being made, there's signs indicating that traffic should turn right to move away from the village and not through it. Now, there's a curious thing. There are, I think, 2 residents in the village that have Airbnb facilities. One of them you may hear from. They're residents who benefit directly from the operation of the premises by selling buildings that they have for occupancy for our guests. And of course, we're very grateful for that. But I think that there are 1 or 2 complaints about pedestrians going back to these Airbnbs. I think there are only 2 of them, and making a noise. Well, we do the very best that we can. And we've got a noise management plan that you have seen at page 12 and 13. Now, this has been instituted by Artemis. I should say that Artemis owns 6 very high-end wedding venues and operate 15 other very high-end venues. And this is not the first time, their first time to the rodeo. They know, if I may say so, precisely what they're doing, and are used to operating venues such as this. Now, when I say that we are a good thing, not a bad thing for the village, we're a good thing in this way, that we employ local people, our produce is all locally sourced, all the meat, all the veg, all the cheese, all the milk, all the butter, all comes from local sources. And in addition to that, we have casual staff who are recruited from the village as well, including William and Dee Dee's son. Now, Scott Bradbury, I'll speak to him in just a minute, is the executive bars manager. He's a former police sergeant, did 13 years in the police force, won an MBE for services to the police force and with an emphasis on drug matters. Nobody's suggesting that these are druggy premises, but it just gives you the caliber of the man and the training that he has given to the various people that operate under his authority at the premises. So just before I call on him, can I also raise one other matter, and it's the off-licence facility. Now, the off-licence facility is not so that we will become a bottle shop, as one of the residents levelled the accusation at us, that in some way we were going to be selling alcohol to punters who were then going to be removing it from the premises and drinking it in all sorts of places surrounding the area. That isn't the purpose behind the off-licence. Purpose behind the off-licence is simply this, that if you, and this happens, rather overbook the amount of alcohol that you think you need for your daughter's wedding, and there are a number of cases of wine left over at the end, the conditions of the licence as they are would prohibit you turning up the next day and collecting the bottles that you paid for, because that technically would be an off sale. So that's why we want it. There's no other reason. And if you wanted to condition the off-sale facility in that way, we'd be perfectly happy for it. But we do not want to sell in any other circumstances other than that. So we have, for example, at what's called 1604, a series of buildings which have been turned into luxury accommodation, and 20 guests are able to be accommodated there. The purpose of the off-sale facility is not to supply them with alcohol in their accommodation at 1604, because Dee Dee and William don't want that. They've spent a great deal of money ensuring that the accommodation is to a very high standard, and the last thing they want is for people to behave badly. The last thing they want when people come to these premises is for people to behave badly and for noise to be created. This is their home, and they do not want to be disturbed in the same way that residents don't want to be disturbed. But they work hard, and you will find before they set about their duties of attending to their livestock, you will find William and Dee Dee scrubbing the urinals at 6 o'clock in the morning. They are dedicated to this. And they have not skimped on any expenditure which is designed to make the residents' lives better. Now, here are some other examples. They put up, at a cost, I think, of £18,000, an acoustic curtain. In addition to that, the atrium in the orchard barn has been quadruple glazed. There's double glazing, and then there's double glazing on top of that. In addition to that, there have been installed 6 air conditioning units, 4 within the orchard barn, 1 upstairs, and then 1 in the bar area, at a cost of £60,000. In all, including the sound ceiling, they've spent £100,000. And all of that is designed to ensure that the residents are not disturbed. And then the residents say, well, you'll have the doors and windows open. You know as well as I do, if you want an air conditioning unit to work effectively, the best way of doing that is by closing the windows and doors. There's simply no point in having the windows and doors open. And so the reality is that although we are asking for windows and doors to be closed after 7 o'clock, the reality is that we'd probably be closing them much earlier in order to ensure, certainly in summertime, that the ambient temperature within the orchard barn is the right temperature. So those are our safeguards. I'm going to say a word just very briefly, because we received on Monday, as you did as well, an acoustic report which had been commissioned on behalf of the residents from Sandy Brown Limited. Now, Sandy Brown Limited are acoustic experts. We don't know who made this report. because they've not signed their name to it. We don't know which office of Sandy Brown made the report. They've got offices in Leeds and Manchester and Edinburgh and London and Bristol, but we don't know anything other than that. What we do know is that this is what we call a desktop report. So whoever compiled this report, and I hope that the residents weren't charged too much money for it, has simply sat down at his desk and cut and pasted a number of policies from a number of documents without ever having visited the site and predicated on the supposition that we were asking for 1 o'clock plus half an hour's drinking up time, and then made a conclusion that there might be disturbance to the residents, ignoring, of course, the empirical evidence that you've got from Ben Ellis, who says, I'm the expert, I am the advisor to the council, I am the officer that is charged with these duties. And I tell you what, I've been to these premises, I've put monitoring equipment in residents' houses back in 2017 and 2018. I've monitored the operation of these temporary events notices, and in my professional view, you are able to grant this license subject to those conditions. So whose evidence are you going to rely on? Are you going to be relying on the nameless, faceless report from Sandy Brown? Or are you going to rely, as I suggest you should, on the evidence from Ben Ellis, who is the person best placed to advise this committee on what the position actually is, not what Sandy Brown presumes it might be. So that then, in a nutshell, is our case. I'm just going to get some nuts and bolts from Scott Bradbury. Scott, can you press your button? We can't press them simultaneously, so I'll ask you a question and then sign off, and then you report back to me. So I've said this, 13 years in the police force, and I've said this also in William and Dee Dee's statement, that you're better placed than most to deal with matters relating to crime and disorder and so on. Can you just in a nutshell explain how many staff you have at the premises and how you train them in order to do what they do?
Chair, good morning. My role as the executive bar manager is to train all of our bar managers up to a certain level. So we have 15 bar managers across the company, full-time, and several full-time supervisors. All of those staff are put through a personal licence course. If they don't have it when they start, we put them through as a company. For out of the year, then, we conduct training on drug and alcohol awareness and conflict management. That's done every 12 months with all of our staff, not just the staff that are covering the bar, but also our event managers and everything else, what to look for and what is acceptable to cover under the licensing objectives, what we need to be aware of, and how to handle if we've got somebody underage and we go for challenge 25, not challenge 21. So it's various training for out of the year. We have a compliance folder which goes above and beyond the requirements, and I say that because that's feedback from local authorities where we present it with all the licensing, the challenge 25, refusal logs, the training is, we've been told that goes above and beyond what is expected. So that's my role in the company.
And then insofar as...
Sorry, may I just say, actually, I think that the councillors, when the depositions are concluded, would like to ask some questions.
Yeah, I'm hoping you will.
Rather than being posed, they would like to actually ask questions.
There are just one or two questions that I wanted to ask Scott, which may or may not help the committee. But if I could just ask these very brief questions. Insofar as the noise management plan is concerned, you, and that's on page 12 of our bundle, you have compiled this, specifically tailoring it to this venue. There are clear areas where there are concerns for the residents, and that is people outside waiting for their taxis and the control of them. Now, we have applied, as I've said. I don't want to tread on anyone's toes.
May I just take some legal advice, please?
Chairman, you can't cross-examine your own witness. If this is how Mr. Rankin wants to put across his case, then...
Cross-examination is rather different from evidence in chief, as your landed legal advisor will be able to help you with. So this is what we call evidence in chief. I'm simply seeking to elicit from this witness specific matters relating to the noise management plan, which you've got in front of you already, and how it came to be in front of you. That may help.
Thank you.
So the noise management plan you compiled, it has been tailor-made for these premises, and it contains sections which deal with control of the car park. Can you help us with that?
Yes, the car park is patrolled during the evening, and then also at the end of the night is we have staff who will go out to the car park to try and usher people into their vehicles and just make sure that everywhere is as quiet as we can keep it as well.
I should say this, that the noise management plan is what we call a living document. And you're perfectly at liberty to extract items in the noise management plan and impose those as conditions. Or my suggestion is this, that you impose a condition which allows this document to maintain its status as a living document, so that if you imposed a condition along these lines, that the premises shall implement a noise management plan and abide by its terms, the noise management plan may be from time to time amended, and any amended plan shall be served on all of the responsible authorities. And what that means is that if something arises that we feel we need to add to the noise management plan, we can do that without having to amend any conditions. So there we have it. William and Dee Dee, the importance to you of having this additional hour is what?
Having the extra hour is going to give us parity with other venues that are able to offer something else that we don't. And as James said, we're 40 weddings down this year, and we would like to try and get back up to where we were.
I've mentioned that there are 6 venues within a 15-mile radius. If one was to go farther afield than that, I imagine many more. But the resistance to people hiring your venue because you have an 11 o'clock terminal hour is what?
A lot. Our venue is not for everyone, and that's for sure. And sometimes we show a couple around, and we can gather that we are not for them, and that's fine. I don't intend to get every booking that comes round to go across the line, but it will give us an equal our competition in doing what we want to do, and I think we do it very well.
That was all I was going to ask these witnesses, and I will tender them for questions from your committee.
Thank you very much. Do we have any questions? Councillor Mills.
Yes, thank you, Mr. Rankin. Thank you. Excuse me, you half answered my question, but you did say that you were losing business because of this extra hour. What is the order book looking at the moment? You said you're down 40 weddings. Most weddings are on weekends, so no? You're shaking your head.
No, not all. I mean, some...
So I was going to say, how does the order book look at the moment?
For this year, we're currently doing about 65 weddings for this year.
And in the past, what has it been in the past?
Last year, I think we did 110 weddings. Year before similar, year before similar.
Thank you.
Any further questions?
Thanks, Chair. Just on that point then, on 40 weddings down, what evidence do you have to say that of all those people, if you like, as you say, that come along, some just don't like the venue, some just don't like the locality, how do you know specifically it's 40?
Hello. Artemis, since we first opened, have always relied on feedback forms for every element of the business that we run. Right down from the minute they arrive, who they meet at the venue, who's doing their show around, all the way through their engagement process. When we first welcome a couple to visit, and they have a private tour, which sometimes, a lot of the time I've done over the last 8 years, sometimes it's a member of Artemis, we actually send the couple a feedback form so that we can build on our own training. It's not just bar training, we do in-house show-round training. And on that feedback form is everything from the time that the event ends, the closing time, to the music, to having the sound ceiling, to having a sound limiter, to absolutely every aspect of it, down to the fact that we don't serve a fry-up at breakfast, we only do a seasonal continental. It has everything on it. And we collate that information on a very regular basis, and we have done since we first opened. You must remember that when we first opened, William and I hadn't run a wedding venue before. My background was as a surveyor and as an interior designer, and William's as a farmer. So in order for us to be what I would call knowledgeable clients, gaining that evidence of how our couples visit us and their expectations, and if we're meeting them, is crucial to us being a business, not just going through the first year, but here we are 8.5 years later. That evidence that you're talking about is what keeps us going. It's what allows us to adjust. And we have 8.5 years worth of feedback saying, we love your venue, we love your gardens. We're winning awards left, right and centre. This morning, again, we're up for another award, hilariously for Warwickshire, Best Wedding Venue of the Year. And yet we have this quite significant financial stumbling block, and it seems to always come back to our cut-off time.
Thank you. Any further questions, please? Yes, Councillor Shunton.
Thanks very much for that. Mr. Rankin, you mentioned the Sandy Brown report, and effectively you're saying that it's a desktop study, it says in the report, but the conclusion was it's considered that these changes represent an increased risk of noise nuisance to neighbouring premises, and this is not supported by any objective noise assessment. How would you respond to that?
The objective noise assessment comes from Ben Ellis. Ben Ellis, reviewing these premises, seeing how they operate with temporary events notices until 1 o'clock in the morning, not 12 o'clock, looking at that, arriving unannounced, we had no idea when he was coming, taking objective soundings of the premises, walking the perimeter, walking the village, doing all of those things. That's the objective assessment that we rely on, not Sandy Brown tapping away at their desktop.
Any further? Oh, no. I will just allow Councillor Shenton to run through the questions that he has written down, if that's okay.
My apologies, I can be a bit of a pedant on these things, so I'm sorry about this. So, when we look at, you said on average the venue holds 75 to 84. Would you agree, though, that any assessment that we make has to be on the basis that you're licensed for 150, not for 75, 84? Because from the impression you're giving, it's sort of, well, you should be assessing it on the fact that there's only 75 to 84, but you could have 150 people there at any one time.
Absolutely right. But all we'd ask you to bear in mind, and this was the reason I make the point, is whilst technically we have a capacity for 150, we never really reach it. So that's what we're asking you to consider. There's the theoretical side. Yes, you could have 150. The theoretical side, for example, about the bifolding doors. Yes, in theory, you could have those open up until 7 o'clock, but in practice, they wouldn't be. The amplified music outside. Yes, in theory, it could be till 7 o'clock, but in practice, by and large, it's going to be well before then.
Just one on clarification. You said there were 4 10s. I see 2, but over 4 days. Is that we're talking about the same thing, I guess?
No, if you turn to page 87, it's clumsily laid out. So if you look at...
Sorry, I have page 87. I'm talking about the 24 ones. I see... Let me just...
Yes, so items 5 and 6.
Yeah. So I see two 10s there, but over 4 days. Is that's
exactly right.
That's what you meant.
Yes.
That's fine.
So,
That
well,
was just for clarification, because you said there were 4 10s. I see 2 10s, 2 references, but 4 days. That's fine.
So if you can imagine that over 4 days, these premises have operated until 1 o'clock in the morning, plus half an hour. And over those 4 days, Ben Ellis has been able to make assessments as to how they performed.
Sorry. As far as those 4 days go, what feedback did you get from residents about it, if any?
None.
What we are able to say is that the up-to-date position on the complaints, you can see at page 89 and 90. These are the complaints registered with the Environmental Health Service. And whilst it's accepted that there were 2 complaints in 2017, in other words, 8 years ago, and 3 in 2019.
Sorry, just to stop you there, I'm specifically talking about the latest 10s, the 24 10s.
Yes, so I'm bringing it up to date. These are, so we've had no feedback from residents complaining, and the Environmental Health Department has not had any feedback. Now, insofar as the complaint list is concerned, you'll see that the latest complaint that they have relates to the 2nd of September 2020, and that is a complaint relating to an evening when we didn't have any wedding at all. So if you can just put a line through that, and then, excuse me. So I've just been asked to emphasise this, that the experience that we had over those 4 nights was that guests don't stay until the end of the night.
Thank you very much for that. A couple more questions then, and then I'll stop at that point. When I look at the noise management plan, you say section 4, external seating areas, regular patrols will take place during an event around the perimeter of the site. Is there a log of those? Do you keep a log of those? Are you able to evidence that, or is that? I'm not being confrontational here, but is there evidence of that, or is it just a statement that, if you like, that's what happened?
There is a log of it, but on past experience as well from local authorities, they say we can write as much as we want down, but it doesn't necessarily mean anything. So there's just regular patrols to the perimeter and to the car parks by all staff.
Scott, can I ask you this? On feedback from residents, have you had any feedback from
Mr. Rankin? I'm happy with that. I don't mean to cut you off, but I'm happy with that. I don't need to expand on that any further.
As chair, I was just about to actually intercede.
My apologies, Chair. That was. I think you were. One more question then. You say taxi drivers will only be permitted to pick guests up from the main car park. Now, you've got this drive which takes it out onto Berryfield Road, is it, or something like? Yeah. So, how can you say will only be permitted? How can you enforce that? Are you saying that no taxis will be allowed to come through the village? So how do you enforce that? I see that as an unenforceable statement, if you see what I'm getting at here, because you're saying taxi drivers will only be permitted to pick up guests from the main car park, but they've got to come through the village, and they may decide to park outside because there are other people or other cars within the area. How do you enforce that?
The first point is that it's not a condition. It's a statement of intent. And so what we do is we encourage taxi firms, the 5 taxi firms that you've seen listed on page 15, those have all been contacted and told to do this. The ultimate threat, obviously, is that unless you do this, we're going to remove your name from the list of approved taxi drivers that we have posted outside the entrance to the venue. So that's the ultimate comeback. But you're quite right. We can't say, you must do this. We will encourage them to do it. And we hope that they will abide by that. Certainly, last year, there were traffic works to one of the 5 roads that goes into the village. And that necessitated some traffic going through the village, whereas it wouldn't have had to have done so if the roadworks had not been there. But now it's back to business as normal. And by and large, what happens is that people come from the right-hand side of that plan and leave to the right-hand side of that plan. But you're quite right. There may be, from time to time, people that go through the village.
May I say thank you for the questions. Thank you for your deposition. Now, I would like to move on to asking Ian Wilson, Parish Clerk to Treddington Parish Council, to come and put his view. Thank you. Yes, if you move to the chairs at the back, if you would. Hope there are enough chairs there for you. Thank you. Okay. Thank you, Mr Wilson. When you switch your microphone on, just remind you to keep speaking to the microphone so it's picked up by the audio system. Thank you very much.
Sure, yeah. Yeah, thank you, Chair. So the first historical application for this venue was to hold a small wedding receptions in the thatched barn and have letting rooms. And at the time, the parish council didn't support that, and it did raise concerns about traffic and noise levels that would lead to a public nuisance. Subsequent to that, parish councillors did at the time support a planning variation in 2017 based on robust planning and licensing conditions being in place. At this time, the rationale was that there was going to be a proposed glass walk to the letting rooms, and this would be a measure to reduce music and crowd noise within the additional buildings, give guests a way of accessing accommodation. And at the time, the accommodation was increasing from 4 to 8 rooms. And this was to ensure that the licensing condition of 11 o'clock wasn't breached. The parish council did also support this this division so that guests could leave the premises at 11:30, and this was so that this could be managed effectively. In fact, the soundproof glass canopy was never implemented. However, the additional 4 letting rooms asked for in the application have been implemented. So the parish council are mindful that the site has grown, and although the parish council is supportive of local businesses, we're mindful as our residents that they don't need to be add-ons with the rural community, that they need to work with the rural community. The venue partners, Artemis Events Limited, are a national chain, and the parish council is supportive of residents who don't see this vision as being acceptable to the character of a rural village. The business is successful, and the business is successful under the current licence and planning conditions. And the parish council does support the village's real concerns that the new licence will see operating hours and noise level from music and crowd constitute to a public nuisance a greater number of days and a greater number of hours. And it's still worth highlighting that although, yes, this is a licensing application, the planning conditions put on the site have always been there in the interest of minimising noise and the disturbance from the premises at sociable hours for the villagers. And this was really, as we saw, so that the venue could coexist with the village. And some of these planning conditions, just highlighting those, there's planning condition 15, the use of the dining barn, being permitted between 9 and 11:30. Planning condition 34, all amplified sounds, acoustic music associated with the function, permitted to cease at 11 on the day of the event. Planning condition 35, activities held in the function room to cease by 11, and all, as was highlighted earlier, all guests to vacate the building before 11:30. And again, this is this is to minimise noise and disturbance from the premises. The original licence application, may recall, went to a panel hearing, and the environmental health officer at the time raised at the hearing that Blackwell had a very, very quiet nature, a nature which was quoted as being 30 decibel at peak times and falling to 20 decibels both day and night. And the parish council does congratulate the environmental health team for producing a set of conditions that protected the villages and houses, particularly the adjoining properties with some gardens adjoining the premises, some of us closest to 100 metres away. The environmental department is congratulated by that. And you will hear from residents who have complained some examples today of issues that have arisen. So the parish council is surprised to find that there's now an about turn on behalf of the environmental health team on the conditions. The conditions at the moment we see as a parish council are clearly working and allowing the venue to exist within the community. And we do feel there has to be more justification for this than the environmental team have not received any complaints directly. Villages have taken the view the best practice in line with the Licensing Act 2023, which recommends address complaints with the venue directly, so that's what's been happening rather than to environmental health. And there is no mention of this in the submission, which I think you've received. And we'd also like to point out that the venue had only started to increase business when COVID hit, and so the weddings stopped at the time, and there were small party restrictions between 2020 and 2022, so that's something to take into account in terms of the number of complaints. And also the letting rooms at Blackhall Grange were not available before this time. We understand some were available in 2021, but all were available much later. So again, it's the more recent period, I think, that's more relevant than over the period since 2017. As a parish council, having listened to the residents, we believe it's premature to withdraw the conditions that currently we see as affording the villagers protection. And in fact, we'd support them being retained if the venue is to continue to coexist. What neighbours we here are reporting now is the letting rooms are in place, there's more disturbances, and again, the residents that are going to speak can share their specific examples with you. So this doesn't really seem an appropriate time to take the conditions which we see as working well away. We understand that other venues operated by Artemis have measures to ensure any music played outside shall not be audible outside of the premises of the boundary. And we have concerns that as a destination venue for functions such as weddings, you don't necessarily get a slow dispersal over the night. It's a gradual dispersal. And that was, again, alluded to in the representation you had before. So this means that residents are disturbed throughout the evening. And we know that the original intention to go to 1:30 a.m. has now been changed, but again, we'd still highlight that if we're reliant on taxis and coaches to be able to take people away from the venue. So to conclude, we ask again that consideration is given to retaining the conditions which the council has been supportive of and seen as being excellent to ensure that the venue's been able to coexist with the community. Thank you.
Thank you. Sorry. Do we have any questions? Just
Thank you, Chair. You say the current conditions are working well, and the case, I suppose, is, or the question is here, is one more hour. What would, in your opinion, be the difference of that 1 hour? Why are you against? Why is the parish council, and I'm speaking to you as your representative of the parish council, rather than for the residents, because we're here from residents. So why is the parish council against this? You say the venue is able to coexist with the community in its current form, but the business obviously they put a case forward that they need the extra business to be able to survive, and so the danger, I suppose, is that it might not be continue to be viable. So, what is your objection? Is there any compromise at all from the parish council on this, on a way forward?
So, as a parish council, we're representing the views of our community, and I say the specific examples can be provided by the residents who've objected. Yes, I mean, personally. I haven't got any experience of the effect of the extra hour, and I've got no evidence around that. But I think listening to the views of the residents will be more impactful in relation to that, and we're echoing those views that it will have an impact.
So just to clarify, your objection is really you're bringing the residents' feelings together, and you're representing the residents rather than the parish council itself.
As a community representative, yes.
Can I just ask a couple of questions, please? You said that complaints have been made directly to the business. Has the parish council kept any kind of log of the number of those complaints, the frequency of them?
Not formally, no.
The other issue is you just mentioned coaches. I've heard a lot today about taxis arriving at the venue. You just actually said coaches arrive. How many coaches arrive at the venue, please?
Again, I've got no record of that, but there has been anecdotal feedback in relation to that, which again, the residents might be able to expand upon.
Thank you. I next have... Oh, yeah, sorry.
Hi, Ian, good to see you.
Hi.
Just going back to the TENS, do you remember the previous speaker said there were no complaints when the TENS application licence was extended? Was the parish council involved in that at all?
No involvement, no.
Okay, thanks.
Thank you. May I ask if the residents would like to come and put their views forward? You did say there would be some residents who wish to speak. She was coming after. So this is his. Yeah. Please, will you give your names first?
Yes, my name is Paul McPherson. I am a resident of Blackwell. I live in New Cottage, which is probably the nearest property to the venue. I'm neither an agitator, and we do...
Can I just take the names first, actually, so we know
Yes,
who's going to be speaking next? So thank you, Paul McPherson.
Right one.
Nick Daniels is my name, and I'm a resident.
Thank you. And?
I'm a resident in the village.
Right. I have my running order in slightly different order than it should be, as I'm just actually being informed. May I actually ask... No, I've got it right, actually. No, I've got it right. Yeah, sorry. Because this has changed a couple of times. So if I may ask Paul McPherson to speak first.
Thank you, Chair. As a resident, I live closest to the property. I live on the Ilmington Road. So I speak on behalf of my wife, myself, and the residents on the west side of the venue. We moved to Blackwell in 2018. Well, we almost didn't, in actual fact, because we, having always lived in small hamlets and villages and looking for the good things in country life, we were quite concerned to read the furore over the Blackwell Grange planning and licensing appeal that had happened. But we drew comfort from the agreement that had been reached and hammered out in 2017 to give the venue the ability to operate in close proximity to the residents with the support at that time of environmental health. And I'd like to, as I talk through my piece here, just make a point, if I may, Chair, that the noise isn't just solely noise from music. You'll hear that there's other intrusive noise that is uncontrolled or has been uncontrolled. So if I go through my piece, hopefully I'll highlight and answer some of the questions and also deal with some of these points that were raised. We think that the agreement that was pulled together, supported by environmental health at that time, was reasonable. And it had realistic planning constraints which considered noise intrusion at a neighbourhood level, not at the perimeter of the venue. Despite this, there are still issues with noise disturbance, and myself and other residents have complained direct to the venue many times. Despite short-term improvements, issues persist, particularly now as they have letting rooms for up to 24 people, and that'll become apparent a little bit later on as well, which is 3 times more than when the original agreement was drawn up. You will no doubt wonder why we haven't complained direct to the council, and I think we all felt that the agreement that had been drawn up was probably the best we were going to get, and that we really have to grin and bear it. But there are times in extremis where more rigorous management by Blackwell Grange of noise, and I mean multiple sources of noise, is vital. Music and crowd noise from the party barn, I will say, is generally well controlled, but would not be if doors were left ajar when music was playing. At our end of the village, and as I said before, as the closest property, we hear a great deal, more so in summer, and I think making a point about the 10 that was in November. There are not a lot of people outside in November, not unless you've got a polo suit. But we, like the wedding guests in the summer, like to enjoy the balmy evenings, and sometimes we find we cannot. And when we retire, leaving our windows open for fresh air, which is our right and amenity, the crowd noise is often excessive and we cannot sleep. My wife is a particularly light sleeper, as is my neighbour, who suffers from health conditions and has to have his windows open. We talk about outside music in the proposal, which currently is unamplified, and it has ranged from a string quartet to an umpire band to bagpipes. One was pleasant, the other's not so. I leave you to guess which. And the prospect of amplified music outside, with a level proposed by environmental health to be at a low non-disruptive level, is ridiculous. By what measurement and how could it ever be enforced? We already clearly hear their non-amplified music inside our house, so surely their guests don't need it to be any louder. We all hear the 3 cheers for the bride and groom in the afternoon before they go in for their meal, and have learned to ignore it. But there are a lot of outside activities in the garden, and these go on into the evening with food served, and the partying continues far and often goes long into the night. Crowd noise can exceed 90 decibels. This is a fact that you can read in any acoustic report. On the subject of replacing the sound limiter with a 10% higher decibel rating through their sound ceiling, may I respectfully highlight, and I do have knowledge in this area, that the decibel scale is not linear. Environmental health will know this. A rise from 80 to 90 decibels is 10 times more intense, but actually twice as loud. This will make it harder to dissipate that sound over distance, particularly if doors are left open. Under current planning conditions, the venue has to cease activities by 11 p.m. and guests are summarily moved out to the car park to await their transport, as the venue has to be cleared by 11:30. Many have a long wait for taxis, and my neighbours and I have had regular instances of loud shouting until 12:45 in the morning. Clearly heard through double glazing, and I cannot imagine the effect of moving that drunken cacophony on by a further couple of hours. How many rural taxis are able to work until these proposed extended hours? We are a rural location, and we're concerned that this increases the risk of people taking a chance and taking to their car rather than face a lengthy wait for a cab. And as we know, and despite signs, taxis will always take the quickest route from A to B. They always will go through Blackwell. They currently do, which is right past our houses, and they ignore the 30-mile-an-hour limit completely. Since the number of letting rooms on site have increased, there are now many more guests who wish to continue their partying outside their rooms. And on one memorable occasion, this was accompanied by music playing on a phone until 3 o'clock in the morning, because it was unpoliced. They have asked for parity with other venues in the area, and forgive me, Chair, if I'll quote some research that we have done, and we've taken 5 within this 15-mile limit and looked at licensing hours and music. If we take Swallow's Nest at Norton Lindsay, they have a license until midnight for the bar and music, but they are 2 kilometres from the nearest village. Mickleton Hills Farm, they have a sound system with a limiter set by environmental health. Outside music is permitted only to be unamplified and must cease by 8 o'clock. They are 2 kilometres from Chipping Camden. Lapstone Barn, the bar closes at midnight. Music to cease at 1:45. The site cleared by 1 o'clock. They are 3.2 kilometres from Broad Camden, 4 kilometres from Blockley. And Primrose Hill Farm, I don't have the hours available for them, it wasn't on their website, but they're 1.6 kilometres from Ratley, 2.25 kilometres from Rabway, and 2.6 kilometres from Warmington. All of these as the crow flies. I'm 700 metres from this property, as are a lot of the residents, certainly within half a kilometre, is the whole of our village. So the reason for the licence variation is apparently to increase parity with other venues, and all bar one are 2 to 4 kilometres away. Extra hours will simply push on the noise of guest departure until 2 o'clock in the morning, or 3 if the original 1 o'clock hour was granted, which is intolerable. The 2023 audited accounts for the applicant show a healthy net worth growth of over £300,000 in the year, representing a considerable income for the sole shareholder. So in short, is the drive for greater profits at the expense of residents. In its own submission to the panel, Blackwell Grange states that alcohol sales are steady up to 2,200 hours, then fall dramatically. And they also report that when they've previously had a 10, and as you heard from Mr. Rankin earlier, the numbers who stayed to the end are surprisingly small. So why apply for extended hours at all? We're not against the venue increasing utilisation, and therefore the number of days it operates, but these should be within the previously agreed planning and licensing frameworks, and the venue must take greater responsibility for departing guests, especially those waiting for taxis, as well as those in residence who've been clearly heard carrying on the party outside after their site staff have departed. In conclusion, Chair and panel members, Blackwell is an extremely quiet hamlet with very low ambient noise levels. Sounds do not have to be loud to be intrusive and travel far into the night. We're not trying to close down this business. We want to be able to continue to coexist. So for that reason, we ask the panel to reject this application and instead renew the existing licence conditions, but add caveats that responsible staff should remain on site as a minimum until all residents have safely retired to their rooms, and who have the power to ask any disruptive guests to go inside and be quiet. Staff members must be empowered to move guests inside from all outdoor areas by 9 o'clock latest. And there must be more and better rigour over noise of those leaving the venue, and also regarding the booking of taxis. If you read the poster in the applicant's bundle, it's extremely ambiguous. It says taxis must be booked by 11:20 p.m. Does that mean when I phone? That's what it says. You can read it two ways. We all have experience of booking taxis at that time of night, and many tend not to arrive, or certainly don't arrive at the time they say they will. So we need better rigour. That's the end of my piece, Chairman and panel. Thank you for listening. Do you have any questions, please?
Councillors?
Oh, I'm flashing here. Thank you for that. You were talking about decibel. Did you do a decibel reading yourself?
No. Sorry, no, we haven't done any decibel readings. It would be useful if Environmental Health had sent us meters to use, but we've not been given anything. I didn't say we'd taken any readings ourselves. It would be useful if Environmental Health had, when they visited the site, actually visited the premises of the residents who are likely to have been impacted by this change and by use of the TENS.
Further questions?
Thank you, Chair. Just thinking about the noise disturbance and the taxis. You say that there's a long wait for taxis until 12:45 in the morning and noise up till 3 a.m. Again, as Chair asked Mr. McPherson, do you have a log to demonstrate exactly what you're saying in terms of, you know, complaints you've made directly there, incidents, and if you've got, and have you reported any of the, if you like, the antisocial behaviour in terms of late night, 3 a.m. in the morning? Has that been reported to the police in any way?
My neighbour has reported the 3 a.m. to the police. That's Mr. Plum, who lives at Cheverny on Ilmington Road. I have approached Mr. Vernon Miller and Scott Bradbury on several occasions, been in contact with them both about noise, but to be frank, Councillor Shenton, it's made no difference at all. It continues, and as I said, I think in my piece earlier on, we've just sucked it up and think it's the best we're going to get. We've had to put up with it, which is not something we feel we can do when the hours get extended further and the nuisance goes on further into the early hours of the morning. That would just be untenable.
Those are all the questions? Thank you. Nick Daniels, next person on the list.
Thank you, Chair. I'm fortunate enough to be situated in a location in the village where I'm not quite as badly affected as Paul, but I've been asked by a few residents to say some words. And forgive me if there's some reiteration or repetition, but really I was coming at it from the point of view of just trying to summarise, I guess, our perspective maybe, and just highlight some points that we think are relevant and give some thoughts. So I've just done a few bullet points. So if you forgive me if I can just go through those to try and summarise. So we have no wish for Blackwell Grange not to continue to operate and be a viable business in the village. They advise us that there were about 100 wedding events in the past year, and they won 2 venue awards in the Cotswold Wedding Awards 2024. So indications to us are that this business is doing well, despite Blackwell Grange reporting that bookings have been down by 40 from the previous year. We do find it hard to believe this reduction in bookings would be solely down to the current licence conditions and restriction on hours. Rather, we suspect it is simply due to the availability of normal competitive alternatives and wider economic conditions. An average of 2 or more events per week still being achieved, in our view, indicates a healthy level of activity. This is a reasonably busy venue, and they advise us they are seeking to increase the number of events held. Blackwell Grange caters not just for weddings, but hosts other celebratory or seasonal events, dinners and workshop type events. Their website notes they can accommodate 150 seated guests or 200 evening party guests and 24 overnight stays. As reported, but worth restating, Blackwell Grange operates its venue supported by Artemis under a commercial arrangement. Artemis's website and published accounts indicate they own and/or operate some 15 venues in the UK, turning over £18 million a year or thereabouts. They are presumably looking to maximise profit too, with this broader context also to consider. Their hosted events are stated to include conferences, award evenings, team building days, and seasonal parties. It is appreciated that since submitting their application, Blackwell Grange has amended their original request to extend the licence activity closure time from 11 now to midnight plus 30 minutes finish-up time. But we still remain concerned that relaxing time constraints potentially attracts more boisterous events and worsens the impact of noise pollution, which is not just a function of the loudness, but also the time it occurs. To reiterate, Blackwell is a small village, even a large hamlet, of about 60 or 70 households with no pub, no shop. Environmental reports have noted the natural quietness of the village. There is an abundance of wildlife, including bats and bird species. We believe that the 31 objections to the requested licence variation raised are significant for our small village. Many of the objections are detailed, and some provide testimony to the adverse impacts and nuisance already being experienced by some residents. You have just heard Paul describe his experience. We do hope these objections and personal testimonies are fully taken into account. It is true that the number of formal complaints made over recent years has been modest, but we believe these have reflected the residents' understanding the previous processes, environmental studies, planning and licensing considerations had been thorough and reached a reasonable compromise. In broad terms, we do not understand how the significant license variations being sought could be acceptable when circumstances supporting the current license conditions have really not changed. We were disappointed that the licence variation request and concurrent planning application were submitted without prior consultation with the village. The requested licence variations at first sight could appear incremental to existing conditions. However, taken as a composite set of variations, they could be quite significant in effect. Later operation will worsen the impact of any noise disturbance. It could also worsen problems of stranded guests awaiting taxis. The request for amplified music outside until 7 p.m, allowing the function room bifold doors to be open until 7 p.m, defeats the event building's sound insulation. Notwithstanding Blackwell Grange's proposed noise management plan, it appears that it is being requested that sound levels be left to subjective judgment and control. The conclusion of the Sandy Brown report, completed on behalf of Blackwell residents this month, states it is considered that these changes represent an increased risk of noise nuisance to neighbouring premises, and this is not supported by any objective noise assessment. The requested licence variations include that sale of alcohol for consumption off premises be approved. Despite Blackwell Grange's submissions, we are concerned this at least has the potential to make late evening, early hours disruption more likely. Finally, we note Blackwell Grange's current licence conditions appear not to be out of line with other local wedding venues. We've noted, for example, only unamplified music is allowed outside for another local farm wedding venue. This venue is not situated in a village at all, and it's about a mile outside Chipping Camden. In summary, given the testimony from those residents in Blackwell already adversely affected by the business, the 31 objections raised, the risk of increased public nuisance, we do request that the licence variations being sought are not approved. Thank you.
Thank you. Any questions, councillors? Councillor Shenton.
Thanks, Mr. Daniels. I will clarify, by the way, when I was speaking to you, Mr. McPherson, before, and I referred to the log, I meant to Mr. Wilson. The chair had asked Mr. Wilson. I ticked off the wrong name on there and realised afterwards. Mr. Daniels, you mentioned the 31 objections, and that's quite substantial. How many people live in Blackwell, and how many dwellings are there?
So I don't know how many people live in Blackwell, but I'm advised in conversations that there's between 60 and 70 dwellings or households. And again, I'm only a resident, just taking that from my understanding of the situation. I can't have no documentary evidence on that.
That's fine, thank you. It's just to give me a broad idea.
Councillor Mills.
Yes, thank you. You say how far away do you live from the...
I live in the fairly central. I'm probably... again, I'm guessing because I haven't measured this, 200 yards maybe.
So can you hear from where you are?
I've only been in the village 18 months, so I've probably, summer is definitely the most obvious time when you're outside or you have windows open. I'd say I would have heard cheering and the odd bit of noise, but not the level of disruption that Paul's had. I've certainly been aware of traffic at certain times. You know, people stop me in the street and say, "Excuse me, do you know where the wedding venue is?" and things like that. So I can't pretend that I'm kept awake at night. I'm probably not. So it would just be some general background noise.
Thank you very much.
Any further questions? No. May I ask Lisa Gilligan to actually put her view?
Thank you. Just to be clear, I'm not a local resident. I'm appearing on behalf of a number of local residents. Obviously, within your report, you've got 31. Those residents all live in the village. You know, they are in the immediate vicinity. The reason that I am here and not all 31 or down to 29 was to hopefully summarise issues for you and avoid a degree of repetition. But obviously, this is a highly contentious application for the village, and 31 in my submission is a big number of local residents who live close to have felt strongly enough to wish to voice their concerns to you. A common theme, and I'm sure you'll have read them all, and I don't propose to take you through them line by line, you'll be pleased to hear, but a common theme running through them all is the history and the fact this licence was originally granted back in 2016, and the majority of these issues were issues back then. Now, Mr. Rankin has said you can't predict the future, you can't predict how premises will operate, which is quite right. But in our submission at that time, the conditions which were imposed predicted quite well They predicted that despite saying at the time, we'll only do weddings, and that is in the minutes from Mrs. Vernon Miller, we don't seek to diminish or ignore that the commercial landscape changes. She thought in 2016 it would just be weddings and the odd charity event. It's not. It's a whole range of events. And with those events come risks. And I think it was you, Councillor Shenton, who pointed out that this licence could be for the maximum. We say we'll only do X. We might not necessarily do Y. This licence won't cater for that. This licence will cater for what you can do, for 200 people, for amplified bands, for music of a variety. It doesn't say just a soprano. It doesn't. And what's pleasant for one bride or groom may be deeply unpleasant for a resident at 1, 2 o'clock in the morning, at 3, 4, 5 in the afternoon, if we're talking about amplified music. And it's what this licence will permit that you must consider, not what might happen or necessarily happen, what you are permitting in its maximum. The sound ceiling, I'm not a noise expert, and I wouldn't proclaim to be. The sound ceiling obviously sounds a fantastic piece of equipment at substantial investment. But I think in our submission, we would say it's disingenuous to state that there haven't been issues for local residents. Local residents, I hope you will agree, those here today and those you've heard from, are reasonable individuals. They want the business to succeed. They haven't been on the phone to your EHO week in, week out. They haven't been calling 111 to get the police out. You've heard from Mr. McPherson. They thought this was as good as it gets. And I think, to coin his phrase, we've sucked it up. We've sucked it up, over the past few years. There have been calls out. There is a number. It's not manned all the time. It's not picked up all the time. And people don't want to call back. It's not how these people wish to live. It is heartening in your policy. I think it's paragraph 8.18 from your licensing policy. It makes it clear that the impact on those that live, work and sleep within the local vicinity will be considered. And living, working and sleeping are 3 very different things, and the impact at different times of day is significant. The daytime noise unamplified, in my submission, Mr. McPherson and those closely affected at the moment, they take a sensible view. They don't wish any happy couple ill on their day. I take Mr. Rankin's point that some people finish their nights earlier. We were all young once. We all went to weddings when we didn't finish our night early. And it'd be my submission that weddings they're family occasions, they're hugely celebratory, and what goes on later in the evening will continue. A wedding is a wedding. And as I say, whilst ever a talented soprano might be what people have asked for, that's not what this condition is limited to. And I don't think you need to be a qualified EHO or work for Sandy Brown to recognise that amplified music outside raises the potential for public nuisance. Having my phone playing outside could disturb my neighbours, but having a sound system, and even if that amplification is inside, which I think was mentioned at one point, if we have bifold doors open, that music is going to come outside. I think Mr. Rankin talked about a £60,000 investment in air conditioning. If that's what we've got, why do we need to open our bifold doors? Because if we do, we will render it redundant. And so again, a condition saying we won't do it because our aircon is there, that's not what you're asking for. What you're asking for is to be able to effectively, and I am exaggerating to make my point now, but you could have those bifold doors open all the time, sod the air conditioning, it's nicer. I've invested all this money. I know people want to come and they want to go. That is what you would be permitting. even that would be the unintended consequence of these relaxations, would be our submission. And then night times. Night times are a whole different ball game. Again, you don't need to be an expert to know between 11 and 7, that is when people expect to be able to sleep. If we push all of this back, we are going to be keeping local residents awake who, up until now, have sucked it up. We've put up with it thinking it will end soon, it has to. But we're going to have revellers outside, and we do now. Cars and taxis, I think, it's been fairly acknowledged, I would say, by the applicant that you can encourage taxi drivers to do certain things. We can't make them, but we put up with it at the moment because we know what the terminal hour is, and we hope that things, will quieten down as we move through the night. And then, of course, there's music itself, and if that were to continue, all of those risks are there. These people are not NIMBYs. They're not seeking to end a business at all. We appreciate the picture that the Vernon Millers and the applicant have painted today, and that may be what they really hope happens. But you have 31 letters of representation where residents give you their lived experience. It may not be logged with the council, but they're telling you now this is what it is like for them. And your legal advisor will be well versed in the leading licence in case of Hope and Glory, which talks about public nuisance. And it could be just one complaint, or it could be something which affects a whole community. And here we're saying to a lesser or greater extent, that's what you've got. You have got a premises which affects the whole village. But we're trying to give you our balanced, our reasonable, and our accurate account of how it is for residents who live near Blackwell Grange. The conditions which have been drafted within the application and are being sought, we do have serious concerns about those, and not to go line by line now, but at page 83 they are. And condition 23 talks about low non-disruptive volume appropriate for the setting. Licensing conditions have to be unambiguous, they have to be clear, they have to be enforceable. What's low and non-disruptive, to me as a party goer, is not going to be the same as it is for the local residents. There needs to be something officers can enforce. There is on the licence already, and forgive me, I think it's condition 26, but I will, if you just bear with me, you'll be able to look this up for yourselves in deliberations. But page 49, there is a really significant condition which says noise from amplified, regulated entertainment shall be so controlled as to be inaudible inside any noise-sensitive premises at all times. That's a condition which is there now. It's being breached now. We can hear music, but given the times, we grin and bear it. And having conditions which talk about low non-disruptive volume, and I think one of them also refers to a pleasant atmosphere, that's going to clash with condition 26, which is which is a lot more unequivocal. It used the word shall. Shall, will, must. These are clear words for enforcement, but there's such a degree of subjectivity there that we fear that actually this is just storing up trouble for further down the line if we don't iron it out now. Residents are and were disappointed, really disappointed that the applicant didn't approach them. Now, on one hand, you could say, well, they didn't know there was a problem. Why should they? They did know there were concerns. They did contact Mr. Ellis and have worked with Mr. Ellis since the autumn. But there's been no contact at all with not one resident, not even Mr. McPherson at the closest. No readings have taken place within any noise-sensitive premises. So how do we know if we don't go inside? And that's what happened back in 2016. Readings did take place. I don't in any way diminish from really hard work that Mr. Ellis has obviously put in working with the applicant, visiting the site. But that same courtesy and level of engagement wasn't afforded to the residents, and hence you're 31 now coming forward to raise their representation. Now, we appreciate, I think, the comments which have been made about the nameless, faceless report of Sandy Brown, but residents had no choice but to, at their own expense, seek some advice, because nobody was talking to them. Nobody was coming forward to say, you know, does this work for you? If we do this, what is it like in your premises? Now, because of, and I'll be brutally honest, because of the shortage of time, this is a desktop exercise. You can see that, but you know, should this continue, then obviously Sandy Brown, the report will need to be expanded upon, and whoever writes the report come before a committee, a court, to talk through. But it's the lack of engagement which has meant that this was necessary. At its highest level, I think you, Councillor Shenton, talked about the lack of objective assessment. That's what we're upset about. There's been no readings, there has been no engagement. And in fact, on that point, and really important, I think, to note, which I hope illustrates the measure of the residents at the meeting back in March, Mr. Vernon Miller was asked to pause this application so that readings could take place and so that there could be that level of engagement. Look, can we just see what you're talking about? Can we hear it? Can you take? And that request was declined. And the response was, we will continue with your objection. That's not collaborative. That then backs the residents into a corner and really not quite knowing how to take this forward. It may be modest now what we're seeking, 1 hour. You know, on the face of it, you think, does it really matter? We're talking about 1 hour. But when you're struggling already and you're being disturbed already, pushing all that back 1 hour or maybe more will have a huge impact. We do have a problem with the temporary event notices. I think Mr. McPherson touched on the fact they were in November. That's not a time when doors are going to be open. You know, it's not a time we're going to be outside listening to a soprano. Unfortunately, it's cold, it's wet, it's dark. But above and beyond that, every single 10 we had was in breach of planning. And I'm not quite sure how that was encouraged. Now, it may be that Mr. Ellis was completely unaware of the planning limitation, but the applicant wasn't. So we're seeking to rely on one level and say, look, we operated 10s, we didn't disturb you, we did readings, all was well, and we're hoping our planning officers don't take enforcement action. Or it may well be that the planning officers are saying, yes, we knew you were in breach on those occasions and we're fine with it. But I don't think it's fair on the applicant to try and encourage 10s as a means of testing the water when we all know that later terminal hour is unlawful. Planning and licensing don't have to go hand in hand. I fully accept that. But there is an expectation you will trade to your to your shorter terminal hour. We don't dispute Scott's calibre as a manager at these premises. He's been there for many, many years. But residents have been disturbed on his watch. They have. And I think at one point he said, you know, we patrol to make it as quiet as we can keep it. They need to go further because they do know that residents, you know, into the night when people who have been drinking, and let's be honest, at a wedding, a lot of people will have been drinking all day and voices get raised and people perhaps behave in a way they hadn't anticipated. I've touched upon the air con, and if, you know, at £60,000, the reality of saying you can have the bifold doors makes that completely redundant if we are going to open them. I think both gentlemen have talked about the parity with other premises. And in our submission, that's just not the case. And it may be in terms of the terminal hour on the licence, but all of those premises are in different locations. They've not got Mr. McPherson, 700, less than 100 metres away. They've not got residents who are going to hear it and be so impacted. There may well be beautiful wedding venues, which obviously are in direct competition to Blackwell Grange, but they don't have residents on their doorstep who are being disturbed. And in any event, you're considering just one application. You're not being asked to comment on just how competitive it is for wedding venue operators, which we don't doubt. As I've said, we have always, well, not always, we have already asked the applicant to pause on the application while NORS readings were taken. That was rejected. So all residents can do now, and have been forced to do, is ask you at this stage to reject the application so that stock can be taken, noise readings can be undertaken, and any extensions which may or may not be granted are with full visibility on the impact on all of those affected. And I do think, whilst ever it is a bit of a chicken or egg, that the planning position should quite properly be clarified first, so that then TENS could lawfully be applied for and the water tested, and then a variation with a track record be properly put to a licensing committee. There are, and I'm only going to touch on this, there is a couple of points made, and I just think it's fair to respond in relation to Airbnbs. The proprietor of one of the Airbnbs is here, and would dispute wholeheartedly the assertion that he benefits from wedding guests taking up his property. And also, I think in one of the submissions we talk about the village hall having a licence until 1 a.m. It does. It's been used once to that later terminal hour, and it was actually post a funeral, which all parties know about. And so I think there are certain people who are quite upset by that particular reference. The village hall is used for quizzes and Pilates. I don't think there is any serious suggestion that it's in any way a competition or a comparator for Blackwell Grange. But as I say, I don't wish to take up too much more of your time. You've got those representations, but it is a very contentious application with a great deal of history and a significant current level of disturbance. So thank you for your time.
Thank you very much. Before we continue with questions, we have been in sitting for 3 hours. So may I read this out? Due to the time and in accordance with the Constitution, a vote is needed to continue the meeting. Unless this vote is not carried, the remaining business will be considered at a time and date fixed or at the next ordinary meeting. Please may I ask councillors if we actually wish to continue with this hearing?
I wish to continue, Chair.
So do I. Thank you.
Continue.
I apologise, I didn't realise you'd been sitting for 3 hours.
May I ask if there are any questions from the councillors?
Yeah, I mean, it's just this question of this extra hour and the difference it's going to make. Could you just elaborate on that, please? I know you've touched on it, the concerns, but could you elaborate, please?
Yeah, I think, and I obviously differ to the gentleman either side of me as well, I think it is because there is a level of disturbance now at the current terminal hour with, with music, with taxis, with revellers outside, and therefore, if that were to push back, because everything is going back an hour, we're now really eating into the early hours of the evening. I would ask you to accept there is a level of disturbance because you have evidence, from those making representations, and we struggle to see how, if the terminal hour gets pushed back, that level of disturbance won't continue at the later hour, whether that's 12:30 clear, taxis coming, maybe late, 1, noise continuing. So I think the real concern about it is there's a level of disturbance now at the existing terminal hour, and anticipate that that will be pushed back. And if we're going to relax anything on the licence, we need to be thinking about those relaxations with a proper noise assessment as well as to what music, etc., will do as that moves back. So I think it's really, we struggle now, we fear we'll continue to struggle.
Thank you very much.
Thank you. Councillor Shenton? Okay.
Thank you very much. Just brief one for clarification, then a question. Did you say back in March you wanted to pause the proceedings?
We're still in March. Yes, there was the application was submitted. It did come as a shock to the village. Representations submitted, and I think it was possibly Vicky. There was a meeting organised. It's quite right. It was first of all at 9:30. The majority of the villagers work. That was really difficult. The applicant did push it back into the evening, and at that meeting, which I think was the 12th. I think it was the 12th of March, when there was the meeting, which I think is referred to in the applicant's bundle, when the sound ceiling and all sorts of things were discussed. At that point, the residents asked if there could be a pause to continue the dialogue, and we would also have wanted noise readings. And so it's, when I say back in March, I actually mean only just a few weeks ago during the consultation period, because we're still in March, so apologies for any confusion.
Thank you very much for that. And then you referred to the case of Hope and Glory. For the benefit of residents, and can you explain why you wish to rely on that case?
Yes, my reliance on that is from a public nuisance perspective, and that was related to a pub and the noise which was created by a pub. The hearing went on to consider many, many things, but at the beginning, the complaints came from the majority from one person, and it wasn't 31 others. But the point being that a public nuisance can be something, and it's way just beyond, in the Licensing Act, public nuisance is given its broadest definition, and it can just be, it could just be a public nuisance if the McPhersons were disturbed, or a public nuisance can be something that affects a whole community, which is both in this case. So my reason for raising it was just to make the point that public nuisance is very broad, and it's a whole range of individuals who can be affected, which in my submission is exactly what you have today.
Thank you very much.
Any further questions? Right, we've got to the point now where, does anybody else wish to speak before we come to the summaries? Anybody else wish to say anything? Okay, thank you.
Sorry, can I just say one more thing, seeing as you've invited? I think the hard thing in this room perhaps is to convey, and forgive me if any of you know Blackwell, but is historically, I think it was more of a hamlet with, I think, 5 or 6 farms, and not a village, and no church, no shop, no pub. I think perhaps it's just the hard thing to sometimes appreciate when you look at the paper from my point of view is it really is a large hamlet. It is very quiet. The sky is clear at night. And so I think it's just when we're making comments and when Paul's talking about the noise and so on, it is very much in the context that it is a very quiet hamlet, I would call it, rather than a village almost. So it's just trying to emphasise that point and the impact then that has on the environment around it. Thank you.
If I may, Chair, just reinforce that. I mean, I stood out the other evening, halfway down the village, and it is exceptionally quiet. It's one of the things that attracted us to the village, and I swear I could have heard a pin drop at the other end of the village. It is that quiet. You have to experience it, really, and live it to know. And anything approaching a 10 decibel increase on that ambient noise level can be considered an intrusion. And that's what we have to be aware of. So where we are is working from a very low noise base. So the possibility of nuisance can be easily achieved. So that's just the point I'd leave you with, perhaps. Thank you.
Thank you. I now ask Mr. Rankin if he wishes to briefly sum up.
Can I deal in no particular order with points raised by Ms Gilligan? The first is this, that they asked us to pause the application on the 12th of January. And because we didn't pause the application, then we're criticised because Ms Gilligan says that that doesn't show collaboration. Well, quite frankly, look at the timeline. We put the application in on the 22nd of January. There then follows a consultation period of 28 days when they have to put in their representations, which they do. And they had plenty of opportunity during that period to take sound readings if that's what they wanted us to do. We then, having received, because we were entirely unaware of the groundswell of objection from the residents, and we were entitled to assume when we put the application in that there wasn't any need to consult with residents because we'd received no complaints. Even Mr. Macpherson, and I have to say he's been selective in the evidence that he gave, because he has indeed been in contact with Scott Bradbury, and he has indeed telephoned to complain about, for example, a light that was shining on his property, and that was amended, and the light was turned off. But what he doesn't tell you is that he took the trouble to call Mr. Bradbury and say this, that just to let you know, this is just to let you know how pleased I am with the way that things are going. I feel it's important that you should know the good as well as the bad feedback. So Mr. Macpherson has taken the trouble to call us and to praise us for the operation of the premises, as well as complain about the light, for example. And Ms Gilligan, clinging on to the number of objections, says this, well, look, there are 31 objections. You will have read them, and I'm not asking you to read them through again. But when you drill down and look at the actual number that are complaining about the operation of the premises themselves, how these premises are impacting upon them, it's less than a handful that complain about the existing operation of the premises. I'm not entirely sure that Miss Gilligan got my point about the bifold doors. And her point seems to be this, that you could open the bifold doors throughout the evening until 7 o'clock. And I'm saying, yes, we could do that. There's something you want to ask your legal advisor.
Concerned that we're going through the arguments again, I was actually informed at the beginning of this that I'd asked for a brief summary at this point in time, before we go to consideration.
With that in mind, can I briefly say this then? That the temporary events notices and the approach that Mr. Ellis has taken are really...
Excuse me, I've just had further advice. Can I actually give you both 5 minutes each for summarising? So, started, can we just start now, please? Yeah. Thank you.
Mr. Ellis's evidence is important evidence, and I take Ms. Gilligan's point about the conditions themselves needing a little bit of firming up. You can do that with the assistance of your learned legal advisor. But the point is this, that the person upon whom you should be placing great reliance, in other words, Ben Ellis, has taken the trouble to apply his mind to this, and the residents say, well, we weren't consulted. It doesn't matter. Ben Ellis was able to view the impact of the operation of these premises during the operation of those temporary events notices. Ms Gilligan says, oh, well, November isn't a proper diviner of whether that's been effective or not. We say, yes, of course it is. Insofar as coaches and buses are concerned, you will see in our noise management plan, we encourage organisers of these premises to, as best they can, to organise coaches and buses. The point about that is that you can remove people, large numbers of people, far more quickly than taxis. And then lastly this, that the importance of the, because Mr McPherson says, well, why are they applying at all if people don't use it? It's the chicken and egg argument. Without it, we can't sell it. If we have it, we can sell it, but the reality is that the take-up is much lower than you might expect. So there it is. It's an application which we say has merit. And for goodness sake, please help us with this. And if for some reason there is a complaint about the operation of the premises, I would say this, that I imagine that these residents will have no hesitation in coming forward and telling you that they have empirical evidence that these premises are disturbing them. But for the present, they don't have that. Thank you.
Thank you very much. Brief 5 minutes for summary, please. Thank you.
If I may, Chair, just one point to respond. I did speak to Scott Bradbury and thank him, and that was for turning down the spotlights that were shining into our bedroom that caused us to have to put blackout blinds in our bathroom and our bedroom so we could sleep at night, which tended to be left on all evening. It is important to try and work together, and I was very polite when I spoke to Scott, and it is true, I did say he needs to hear the feedback, good and bad. But after a while, you know when the improvements are only temporary and you stop seeing them, you stop ringing because you realise it just isn't any good. Thank you.
I will be brief, I promise. This is clearly a very contentious application, and it's a very difficult balancing act for you as members of the committee to decide. And I think I would just summarise in a few ways. There have been no readings from the closest noise-sensitive premises, and in our submission, we need them to be able to have the full picture. I can't agree with Mr. Rankin to say that it doesn't matter if residents aren't involved. It does matter. There is a review option. There is Magistrates' Court appeal. These are not individuals who want to be and put anyone to the time, expense, or quite frankly for local residents, the emotional toll of having to go down that route. They want the dialogue to be open. They want there to be collaboration. And unfortunately, that has withered. And it may well take a decision from you today to bring that back. And that's what we're asking you to do. Consider this licence in its entirety, not what theoretically might happen or with a low take-up. It's the reality of what you'd be granting that these residents are going to have to be left with and endure. And sucking it up any further is intolerable. So thank you very much for your time.
Sorry. Thank you very much, ladies and gentlemen. That brings the this part of the hearing to an end. We will be in communication with you within 5 working days. Thank you. There is no urgent business on the agenda, so I now call this hearing to an end at 1:25, I believe. That's right, 1:25. Thank you.